link?
Yeah.
Okay.
Yeah. Okay. We can start. Okay. Hello everyone. We welcome you to our free webinar 10 Privacy Questions United Kingdom. My name is Igor Kotkov. I work as a privacy lawyer for Legal IT Group. Today I'm replacing my colleague Kate, and I have a huge expertise in the privacy and data protection field as well, so I think there is no problem. Today we're going to discuss with our speakers some key and challenging questions that may arise when you work within United Kingdom data protection field and privacy overall. For this event, we invited privacy experts from the United Kingdom who will share their expertise with us. So the speakers today are Mark Povey, Technical Director of JSIG. Mark Povey has been involved in data communications and encryption for over 30 years. And our speakers today also will be Larisa, Munteanu, a data protection lawyer and deputy data protection officer at JSIG, who has sharp expertise in artificial intelligence and data protection field. So let's talk a little bit about format of our event. The format is pretty simple. I ask our speakers some questions about privacy and data protection in the United Kingdom, and they answer them. But if you have some other additional questions, you can also write them down in the chat, and I think our speakers will be happy to answer them as well. So I think we are ready to start. And the first questions to you, our speakers, who you are, tell us more about your experience in data protection.
So, good morning, my name's Mark Povey and I'm the Technical Director and Lead Data Protection Officer of JSIG. I've been involved in data protection for a good number of years. I have worked as Data Protection Officer at Queen's College and Cambridge University, Transport for Wales Rail Services, and many, many others. So my experience covers the wide field in terms of client expectations and deliverables. We run DSARs as a service and many other things, and I'm kind of the coordinator for that. Over to you, Larisa.
Good morning, everyone. My name is Larisa, and I'm the data protection lawyer and deputy data protection officer. My experience is mainly academic because last year I graduated from the master's degree, and then I joined this amazing team at GS Information Governance. But before that, I had experience in the data protection industry only by writing both my bachelor's degree thesis and my master's degree thesis in this field, by publishing articles in this field, and by taking part in different global competitions.
Okay, thank you. It's really huge experience. And the next question to you is what drives you in the privacy industry?
So I think it's fair to say that the privacy industry, while still young, is maturing very quickly. Lots and lots of organisations long believed that the privacy requirements and regulations didn't apply to them, and they didn't understand them. So an awful lot of these companies have tried to make themselves compliant with the regulations, and I think it's fair to say often failed. So the industry is very rapidly becoming a reactive industry, in so much as a company may be 2 years into a project and they've realised they've hit a stumbling block. So they're reaching out to people like Larisa and I and the rest of our company to actually help them achieve compliance. And once they get it, just as importantly to maintain it, and also understanding what the other regulations are that are out there.
For me, I think the most captivating aspect of personal data protection and privacy is the uncertainty. And when I say uncertainty, I mean that you might know the legislation today and the standards that you need to adhere to today, but it's not sure that tomorrow it will be the same. There might be 3 more laws tomorrow, there might be 3 more obligations that you need to comply with. And that's a very interesting part of the privacy part. And at the same time, since research is one of my biggest passions, these two elements are more than compatible together.
Okay, thank you. That's true. Privacy industry is very young. And the next question is, what is the main privacy act in the United Kingdom and other related laws in this field?
So the UK, it still sees the UK GDPR as the core regulation, but on the back of that, we had an Act of Parliament in 2018 which enshrined GDPR into the UK law, and that was the UK Data Protection Act 2018. And people will often say, "Oh, I can't do that because of GDPR," but there are a huge host of other regulations that we also have to respect. The Freedom of Information Act from 2000, the Privacy and Electronic Communication Regulation 2003. I mean, that's very similar to the European Data Protection Directive. And what's happened is people have conflated the two. So the PECR was further refined quite recently to actually reflect what goes on with GDPR a lot more. So we do have to consider all of those, really.
Okay, thanks. Larisa, have you something to say?
No, it's fine,
Okay.
it's fine.
Okay, the next question is interesting. What is the connection between the EU GDPR and the United Kingdom GDPR? Anything essential to be taken into consideration when entering the UK market? What companies should take into consideration when they enter to UK market in terms of GDPR?
Yeah, well, first of all, the connection between the UK GDPR and the EU GDPR is very tight, because at the moment the UK GDPR still retained mostly of its content from the EU GDPR, but this is about to change, we believe, because the UK government intends to amend the legislation right now. So they have proven a tendency to want to amend the legislation in the last few months. And for example, they want to remove the obligation to consult the ICO prior to conducting high-risk processing activities. Or another example is that they wanted to remove the records of processing activities. And the rationale behind this is that they want to offer more freedom to companies to be able to create their own privacy management programs, so internally. And I believe this answer is related to the answer that I gave you before, so uncertainty. So if a company wants to enter the UK market, I think it's very important to carry out their diligence obligations, and that means to understand the legislation too, because there might be some tiny differences that exist and that you might not know about, and that can create difficulties when entering the market, because any company wants to be compliant with the law. And since the UK is a common law system, you need to check the jurisprudence too.
Okay, thanks for the answer. And the next question is pretty similar to the previous question. Are there other global regulations that have an impact on UK companies in terms of data protection, of course?
I will answer this one too, because it's a complex issue. Let's say the UK is not part or is not covered by a single global regulatory document like a convention, let's say, but the UK is a signatory party for different agreements or different treaties with external parties, so other countries besides the EU. For example, there is an agreement with the US regarding countering serious crimes. So this agreement has clauses that refer to personal data protection, and it was enforced in 2020. Another example is a treaty that was signed with the People's Republic of China, referring to customs matters, and it was enforced last year. So the UK is pretty active in terms of personal data protection internationally, let's say, but not to this global level of networking.
Okay, thanks a lot. And the next question about data protection authority in the United Kingdom. We know ICO as data protection authority, who has a great website, who issues guidelines on different privacy matters. And what do you think about their activities? And should one listen to ICO advice? Yeah.
So I believe the ICO provides valuable advice. This is my opinion, and its perspective on personal data protection is cutting edge because there are many cases in which the ICO has provided decisions that are outstanding and that are not frequently seen outside the UK. And at the same time, the ICO has a broad spectrum of legislation that it covers. So it's not only the GDPR and the Data Protection Act, but also the Freedom of Information Act 2000, the Privacy and Electronic Communications Regulations, Environmental Information Regulations. So it's not the simple GDPR that we know that a supervisory authority will monitor its compliance. It's more than that. And to provide you an example with an amazing and interesting case, the ICO has sentenced to imprisonment an individual because of an unlawful transfer of personal data, and that is kind of unique. If you think that in the EU that there are countries that have the possibility to sentence to imprisonment such conducts, but haven't done it, yet the ICO has done it, and the ICO has proven to be a model and an example of understanding the risks and the threats in such situations.
Okay, thank you. I agree with you, Larisa, because I think ICO provides really valuable pieces of advice to data protection practitioners. And we in Ukraine also trying to adhere to their pieces of advice. So the next question is interesting. Fines in the United Kingdom. What is the most interesting cases in which they were imposed?
I think from where I sit, one of the most interesting cases was the Marriott hotel chain and their ingestion of the data from the Starrywood group when they purchased them. And there were several mistakes which were made, which led to a very large fine, which was £18.4 million. And the ICO imposed that level of fine really because Marriott hadn't done their whole diligence piece in actually understanding what the data was that they'd ingested, what the impact of that data could be should something go wrong, and indeed not actually really understanding that there was already a threat vector hidden within that data. So when the breach happened, they didn't really know what had actually breached. So they couldn't take the adequate actions post a breach, such as informing all of those people that their rights were egregiously affected by the data breach. And so the ICO, whilst I think they were a little bit late to the table imposing those large fines, they've now really gripped the nettle on that. You know, British Airways are in receipt of a large fine. But as Larisa pointed out as well, they are now fining individuals for breaching the regulations. Because for a long time, the belief was that I'm not a company, the Data Protection Act 2018, UK GDPR, and all these others doesn't apply to me, so I can do what I want, rather. You know, we've actually had an instance of a guy being fined huge amounts of money because he had Google Nest cameras overlooking his neighbours, and his neighbours complained that it was in effect unfair processing and many other things. So the fines are happening more and more. We've had NHS administrators being fined for moving patient data with no legal basis. They just moved it on. We had a school headmaster who moved his student data from one school to another on a USB stick. Probably an innocent act, but it was actually an unlawful data transmission, and therefore he was fined. You know, at the end of the day, he's now lost his career. So it didn't just cost him the fine, it cost him his entire livelihood and his professional reputation. So those fines are real. They don't just give fines for the sake of it, but when they do them, they are considered and applied very appropriately.
Thank you, Mark. It was a really interesting case. And the next question for you, can you share your experience in working with data subject access request from the United Kingdom, or can you share some of your experience from when you obtain data subject access requests from other jurisdictions working within United Kingdom?
Yeah, so I think the biggest issue companies encounter, or one of them rather, when they receive a data subject access request, they don't actually understand what the data subject is requesting. They don't understand what they, as a data controller, have to provide. Most organizations know about the 30-day limitation, but they don't really understand how that actually applies. So we find at JSIG, and me as the lead DPO, the first piece of the DSAR that we do is educate the data controller as to what they actually need. So when we say to them, we're now going to process the DSAR for you, because we will do that on their behalf, we have to guide them on how to actually collaborate with us and actually give us data that is meaningful to the data subject. We had a large UK charity who had a complaint upheld by the ICO that we stepped in after that. And they basically hadn't understood what the data subject access request really was and what the data subject wanted. So when they delivered the data to the data subject, there were many tens of gigabytes of data that the individual concerned couldn't troll through, couldn't understand, didn't contain the data they were looking for, and therefore the data subject access request was handled incorrectly. And the ICO then really had a problem with them. Thankfully, we stepped in, we corrected the problem. We actually enhanced our technology, so we now have multilingual names within our technology, so we could find Arabic names. Next, who knows, it could be Ukrainian names either. But our technology, we've written it, our team have written it, so we can really speed up DSARs for large entities. We've had DSARs within the colleges that we've worked with, where it's been students who haven't got a position. So they've gone, I know, we'll have some fun at the expense of the college. We haven't been given a place. We're going to have a little bit of revenge. So the college just pass it straight over to Larisa and I and Sonny and the rest of the team back at the office. And we just process it well within time, accurately and correctly. And the data that we give back is in the format defined by the law. So the data subjects are not receiving things that they can't interact with. I know one company that decided the best way to do it was to print everything out and send them reams and reams and reams of paper on the vague hope that the grievance that the data subject had raised couldn't be answered to because he or she couldn't be bothered to go all through that data. Needless to say, the ICO found against that company, and they then had to redo it electronically and at a large cost. We also get DSARs which are requested under the Freedom of Information Act. Now, whilst the two regulations are related, they are not the same regulation. And indeed, for us as a company, myself, Larisa, and the rest of the team, we then have to guide those organizations through which parts of the request are the DSAR and which parts of the request are the FOIA. And then usually we'll respond to the request on their behalf as well, because it is a very large minefield. And if you cannot adequately interpret or understand the request, then you can't adequately return the data. So you leave yourselves up for further fines, further problems with the ICO. And again, using a company like ours, we cut all of that out. And so, we have a wide range of experience.
Okay, thank you, Mark, for the broad answer. as I see, data subject access request is an important part of work field of data protection officer.
Yes.
And the next question is DPO role in United Kingdom businesses. When DPO, for example, is mandatory for businesses, and what are the main challenges for this role in the United Kingdom?
So the DPO role in the United Kingdom is the same role by definition as it is within the EU as defined by the GDPR. What I would say is the requirements vary from one region to the next. So one of the things that the ICO insists a DPO should be in place is if you have more than 250 employees. Are you a mass processor of sensitive carriers of data? If you are a council or a public body, you must have a DPO. So it's very similar, but again, quite different. But I think where the DPO has challenges when he or she joins an organization is actually setting the expectation of what the DPO will be doing. Because quite often, the managing director, the CEO, the CFO of those companies believes that the DPO is going to come in with magic data protection dust and literally wave his or her magic wand. The dust will go over everything, and all of a sudden, all of their data protection problems will go away. My argument is always when we're briefing a company on setting on a DPO or engaging with us as DPO as a service, the DPO is actually really the conductor of the orchestra. So he or she will actually look at the problems in front of them and then assign those tasks to the relevant people within the organization, because the DPO is one part of a team. So he or she will be seen as being middle management, but they are a very important piece of the machine. And quite often, the DPO will be responsible for giving the CEO and the rest of the C-suite bad news. And they won't like that. They won't like the fact that they're getting bad news, but that's what the DPO's role is today. He or she is there to really highlight where big mistakes are being made. And where big mistakes are made, that's when the big fines get applied. And as Larisa touched on earlier, that's when the ICO will start to punish individuals. So, you know, the DPO has to educate the whole team on what their roles and responsibilities are, how they handle DPIAs, how they handle DSARs, how they set up records of processing activity, and then supervise that. Not do them. He or she doesn't have to keep filling in the ropers, but they really have to be a core part of the team and how the team steers its way through the problems of rolling out new systems, bringing in companies that they've bought in. All of these things the DPO should be involved in right at the beginning. But more often than not, the DPO is brought in when the problem has become quite a major problem. So again, the first things that Larisa and I highlight when we start working with the company, we need truth, we need honesty, and we need accurate and timely responses to questions when we raise them. That way, the bigger problems that can arise from problems within breaches, etc., will be minimized and hopefully altogether got rid of, because the education piece is key as well.
Mark, thanks a lot. I have a question. What do you think if company doesn't actually know whether it should designate a data protection officer? What in this case such company should do? What do you think?
So they should seek advice. So they should reach out to companies such as ours or their lawyers potentially if they have corporate lawyers in place to actually understand whether they need a DPO. Obviously, the ICO gives guidance on that. So they can go onto the ICO's website and consult that. Sometimes I think that the guidance could probably be better for something like a DPO, because even if you're not lawfully obliged to have a DPO, if you've got large revenues, if you're a company that's processing payroll for other companies, for example, you really should get a DPO, because you are going to have further exposures that you aren't thinking about because you're busy doing business.
Okay, if I get it right, the better option is to seek advice from the professionals in the field.
Exactly that.
Okay, let's move on. This interesting question. What do you think about any predictions in United Kingdom privacy regulation for 2022?
So shortly, we do expect many changes in 2022 because the UK government has also expressed this opinion already. So as I told you before, they want to amend the regulation in the data protection field. And at the same time, I would like to mention a national study that was conducted last year in the UK, and DPOs were questioned about their main concerns in this field. And for the last year, international data transfers were the most challenging ones for DPOs. And that leads me to my next conclusion, that is, this year will definitely bring developments in the field of international data transfers. And the ICO has this opinion too, and will surely implement new methodology in this field. At the same time, the UK government has mentioned that the UK wants to become the fourth global model in the industry. And that means we'll have the EU, the US, and more recently China. And then the UK, which will be the fourth global model if that will come to life.
Okay, thanks a lot, Larisa. And I think we finished with the list of prepared questions, and we have some questions from the chat. And our viewers, please write down your questions, and our speakers will answer them as well. So we have a question from Mr. God. Can one sell the user's data in the United Kingdom? What do you think?
Shall I answer that one? It's one of my particular favourite subjects. You can't. And there are many rules that prevent that. If you go to the extent, however, of seeking the consent from every single member of that list of data that you hold, outlining very explicitly why the company that you're selling to the data to is going to use it, how they're going to use it, how they're going to contact you, then you possibly could. But in reality, you shouldn't. You know, it's the data shops that are out there have spent a lot of time really working hard on becoming compliant with the regulations. And quite often, as Larisa and I have found, they're still not. So the best bet is to say no.
Okay.
And in addition to what Mark said, we just had a debate this week about selling data. So it's a very on point question right now, because we discussed whether such a contract would be actually lawful or not. It's not asking whether it's lawful in the UK. It's asking whether it's lawful on its own anywhere, because it's the same issue. You can't really sell data.
Yeah, that's true. And we have another questions from Stas Kovalenko. What agreements and other safeguards do companies in the United Kingdom use when transferring personal data to the United States?
I think that one's for you, Larisa, in light of our recent exercises.
Yeah, well, we actually have clients that have this issue of transferring data to the US. And what we do in practice is that we add specific clauses. So just like the standard contractual clauses that you might know, in which you add additional safeguards for the data subject, because since there are differences in legislation between the US, so the specific state in the US, and the UK, you need to make sure that the safeguards that are mentioned by the UK legislation are maintained even if the data is transferred. So this is what we do. And also we check to see if the supervisory authority is the ICO, because you can add this in the contract as well.
And I think, just as an aside to that, we have heard organizations being told they shouldn't really work with the US where data needs to be shared because of what is happening. We wholeheartedly disagree with that. And as Larisa said, we have the tools and the methodologies to allow companies to trade relatively safely with US entities, because we've got a lot of experience with it. A lot of our client companies actually have US entities, US partners, So we're more than versed and we're quite happy to help people with that.
Okay, thanks. I have additional question. There is a transfer impact assessment procedure, and what do you think whether company should conduct transfer impact assessment regarding the loss of third country? For example, if the company send or transfers their personal data to 100 countries, how the company should conduct all of these transfer impact assessment procedures? What do you think?
So we call it a discovery session. So it really is, you cannot just do broad brush. So we have a questionnaire that we supply that goes out to these entities that will give us some initial answers on whether the entities that we're going to be processing data with actually have very good, very accountable systems and technology for protecting the data in the same way that we would within the UK. So it is really a question, answer, check, question, answer, check again, then do a risk assessment based on what we know, and then we'll make a decision on whether we can transfer the data or not.
Okay, thanks. And we have another question from Mr. God. How to become a DPO in United Kingdom? Does one have to be a United Kingdom lawyer?
No.
No, it's just my case.
Okay.
No, it's, you know, the definition of the role is you should be somebody who has the ability to express very sound, very good knowledge around the data protection regulation. So I've sat through quite a few courses, as well as actually applying my knowledge and then testing that application. So I actually finished it with it as an official certified data protection officer, but anybody in principle can call themselves a data protection officer. And we've encountered this with one of the other members of the team, John and I, and we met up with an organization. We've got a data protection officer. Oh, that's good. Who is he? You know, because we, as I said before, we've written our own technologies. They wanted to license that technology. And when I spoke to the individual, it turned out he was halfway through a postal course on how to become a data protection officer. So you should really go through the adequate training and have adequate knowledge. And if you're a data protection lawyer, that's fine.
Okay, forget it, right? You don't need to be a lawyer to be a DPO in the United Kingdom. Okay. We have another question. If a company has a data breach and my personal information is taken, what does the company have to tell me about this? And what does the company have to do to prevent this happening again? The viewers today are really active. So thanks to you.
Thank you.
Larisa, do you want to answer it or shall I?
Well, I can begin and you can take the second part.
It's a complex question, yeah.
Yeah. So since this is a case-by-case analysis, we need to check if the data breach has significant consequences, and if there are significant consequences, that means there are serious threats towards his or her rights and freedoms. And in this case, the individual must be notified about the incident. Otherwise, it's just a simple security incident if it's an insignificant data breach. At the same time, if this occurs in a company, it means that there has been something that didn't work out the proper way, so correctly according to the law. And that means the company needs to check what was wrong there and to fix it for the moment and for the long term too. So the consequences are diminished, are reduced for the moment, but the consequences in the future will never happen. So Mark, if you want to expand on that.
So I think it's worthwhile, Igor, mentioning that in reality, before a data breach even happens, you should know what the data is. So, because part of that is how can you look after data if you don't know what that data contains? So again, we would always suggest actually carrying out as part of your compliance project a data audit, so that heaven forbid, if you do have a data breach, you can actually respond within the time frame constrained, within those 3 days, and you know what the likelihood of that data is in terms of would it affect the rights and freedoms of those data subjects. in other words, is that data breach egregious? If it is egregious, Larisa rightly said, you have to report to the data subjects concerned, you have to report to the ICO, and you have to go into your full incident management processes. How did the data breach happen? First and foremost, if you can't understand that, you can't really plan to prevent it happening again. So it really boils down to avoiding data breaches where you can. So doing things like implementing ISO 27001 as part of your data security application, and the way you go about privacy by design and default. So that way, if you have a breach, one would hope that it's very minimal. One would hope that you've protected the data in such a way that, yes, the data's escaped, but we don't know whose data it is. So if we're one of those evil actors sat behind the power of the dark web, they're going to get data which is in effect useless to them. But if you do have a breach, as I said, you must have a really compelling and easy to understand incident plan, so you can respond quickly, you can take corrective actions quickly, you can demonstrate to supervisory authority, the ICO, that you've done that, because what that will also do is it will help reduce any penalties they may impose on your organization. So do consider other stuff.
Okay, great. Thank you for such detailed answers. And we continue our QA session. And Zoran Matushenko asks you, is there any UK privacy compliance checklist? You talked about ICO compliance checklist. Maybe there is another sources where you can find them.
So we're gradually moving toward that. There is going to be ultimately an ICO recognized accreditation. We're not there yet, but it is moving through. So what the ICO has done to now is there are the 12 steps that the ICO insists that you carry out. So if you've answered those 12 steps positively, then officially, as we sit right now, you are compliant. I would argue that you're not, but you are more compliant than when you started. But as things move out, as changes to the ISO come about, these things will happen. So the ISO is having a data privacy piece created. It's 27701, I believe. Carrying that exercise out to reach those will mean you are far better in terms of your compliance footing than you were before.
Thanks a lot. And now I'm checking the chat, and I think there is no questions here. I believe we could talk more and more about privacy, about data protection, but I think we need to finish, or not, because we have some other additional questions. Okay. If an individual interacts with some content on our website but hasn't consented to marketing and is not an opt-out, can we send a transactional email acknowledging his interest in that content? Okay, complex questions too. What do you think?
It kind of depends on the content of your website. If your website has that privacy notice that says we are going to email you, you can argue that they are creating a legitimate interest, because they have said, hello, I'd like to know about the shoes that you sell. I'd like to know about the hats that you make, because you are actually carrying out an action in which you understand what you're doing. You haven't turned up at www.oversizeshoes.com by accident. So as long as your privacy notice goes through that, yes, you can. But if you haven't supplied that information, then you can't anyway, can you? So if you go onto a website and do not provide your email address, they're not going to be able to email you. You know, there is quite often a misunderstanding about how this stuff works. So as long as the data controller responsible for that website has taken certain actions, then yes. Now, if then you say, sorry, I don't want to hear anything from you, that's an opt-out, and you must treat it as such.
That's true, thanks. And I think the last question that we have, would the answer be any different for countries? This additional questions to previous one. Would the answer be any different for countries operating on consent-only basis and countries operating on legitimate interests? Okay.
I would say so, yeah, because in this case, you don't have legal ground if your legislation doesn't allow you to process personal data based on legitimate interest. So if your legislation simply says you can process personal data based on consent and you don't have consent, that means it's unlawfully processing personal data.
Okay, thank you. And now we can finish our webinar. Thank you for watching, guys. And thanks our speakers for taking part and share their experience. We have plans to organize more and more such events in the future, when we invite great professionals in data protection and privacy field. Please leave your feedback, smash your like button, and write down your comments. Write down in the chat right now, what do you think about this format, what do you think about speakers, and Mark and Larisa, if you have something to say to our viewers, you can do this now.
Go, Larisa.
Well, it was a pleasure to be here today, and I really want to thank you to all the people that asked us questions today, because it demonstrates to us that we really managed to deliver our information to you, and that you understood something, and that you really have an interest into the way the UK has competence in the field of personal data protection, and we are looking forward to other such opportunities in the future.
Yeah, indeed, and I think it really has been valuable for myself as one of the company directors to see the questions that are coming from outside of the UK, actually, and also looking outside of the EU GDPR bubble. So again, thank you for those questions. It has shown a real desire, if the understanding isn't there, to actually have that understanding, and hopefully to really implement what Larisa and I have talked about. And if you have any questions on the technologies that we've developed, please, through Igor, do reach out, and we would be happy to get on a private call and talk through that technology more in depth, because it is incredibly helpful.
Thanks, Larisa. Thanks, Mark. For me, it was really useful to hear some tips and tricks from experts, and I think it's time to say goodbye. Yeah.
Thank you very much.
Thank you. Bye-bye.